invitation. It's always a pleasure. I always say I like to do some prevention, because most of my job is fixing problems after they've already occurred. So it's really a pleasure to be able to be in a place where we can talk about what we can do to identify and prevent problems before they become problems. So some of you know me already or have seen me, but just to give a little bit of background, I don't know this for sure, and I keep saying I'm going to confirm this, but I am pretty confident that no one in the U.S., or if there is someone, it's probably only one or two people who represent more private K-12 schools than I do. We're General Counsel for Pacific Union Conference, Pacific Union College, Northern California Conference, Arizona Conference, Nevada-Utah Conference. We're a Special Counsel for Southeastern and Central, and we're also one of the General Counsel for Southern California Conference. So every single school and church, but every single school within those organizations we represent. And then we also assist in other conferences outside of the Pacific Union. And we also assist Hawaii Conference's education department from time to time with issues that may come up. So one of the things that I really enjoy about my job is I get to work a lot with teachers, I get to work a lot with schools, and I just feel it's one of the more meaningful parts of my practice. I also get a lot of interesting experiences. So as we go through today, you'll hear a lot of examples from actual cases or scenarios or incidents that I've dealt with. So some of the things may seem too crazy to be believed, but pretty much everything you're going to hear from me is exactly from a case or situation that I handle. Now, everybody loves sexual harassment training. California actually requires now for any employer of a certain size that they have to train all of their supervisors on sexual harassment, because California has made it a fundamental public policy to do what it can do to prevent, to educate people on what it is, and then to prevent it from occurring. Now, what's interesting about sexual harassment is that sexual harassment has not been illegal for very long. You know, you would think that sexual harassment has been unlawful for quite some time, but it actually really wasn't until the 80s when the courts started interpreting already existing civil rights laws to include protections against sexual harassment. So today we're going to talk about some general topics. We're going to talk first about sexual harassment law overview, which is applicable in a variety of contexts. It's primarily developed in the employment context between adults working in a company or some other organization. But the same principles are going to apply, for the most part, with some modifications we'll talk about, in the school environment between teachers and students, teachers and coworkers, and even students to students to a certain degree. Once we kind of go over the basic overview, we'll talk more about teacher to student sexual harassment, misconduct. Then we're going to talk about student to teacher sexual harassment and misconduct. And then lastly, we're going to talk about student to student sexual harassment and misconduct. All of these have gotten a lot of attention over the last few years, but you've probably noticed that there's been a big push when you talk about student to student. Of course, at the college level, you think about Title IX and everything you're hearing about sexual assault prevention. There's also a big push in the schools, oftentimes under bullying programs and things like that, to deal with student-to-student harassment. And a lot of times, student-to-student harassment includes sexual harassment and misconduct as a major component. So let's talk about sexual harassment law in general. So sexual harassment is generally considered an illegal form of sex discrimination. Title VII was a Civil Rights Act, Federal Civil Rights Act that was passed, and it included a number of categories. One of them was sex, and sex initially was not really defined to include sexual harassment, but like I mentioned earlier, around the 80s, the law started to develop and really got a foothold in the early 90s from a number of high-profile cases that defined what sexual harassment is and made it clear that sexual harassment is a type of sex discrimination. And the reason why is that it negatively impacts someone based on their gender and their ability to enjoy the rights that they should have in their workplace, and therefore the courts have said that's actually a sex discrimination issue because it's based on gender. They're being treated differently and they're being denied things based on gender. There's two general types of sexual harassment: quid pro quo and hostile work environment. So who here has heard of quid pro quo? You know what that means? What's it mean? No?
I've heard it.
You've heard it, all right. Quid pro quo is a Latin term meaning this for that, right? Hostile work environment is a little bit different. We're going to talk about what these two things are in a little more detail. So quid pro quo is a type of sexual harassment that causes a person to believe he or she must submit to unwelcome sexual advance in order to participate in a program, activity, or function. It causes a person to believe employment or an educational decision is going to be based on whether that person submits to unwelcome sexual conduct. Now, it's not hard to imagine examples of what this might look like. If you're in the workplace, forget about school for a minute. If you're working at some tech company and your boss tells you that, you know what, I know you'd really like this promotion and I think you're qualified for it. If you sleep with me, you can have this promotion. That is textbook quid pro quo. They're trying to tell you that, hey, do you have sex with me, you get a promotion. That's sex discrimination, it's sexual harassment, quid pro quo, because it's directly offering this for that. So that's what that type of harassment is. And if you look at it in kind of a school environment, you can imagine, for example, a professor who may offer a grade increase for certain sexual conduct or favors. Obviously, again, they're offering something in exchange for sexual conduct, which is unlawful. It's unlawful quid pro quo sexual harassment. So that's one of the ways that liability can arise, but hostile environment is a little bit different. Now, everybody thinks, my law firm does a lot of employment law, both plaintiff and defense. And I can't tell you how many calls we get from people who think they have a case because their boss is a jerk. And they feel like, I'm in a hostile environment. My boss is mean to me, he makes me do things I don't want to do, he yells at me. At least not yet. Hostile environment in and of itself is not illegal. Bosses can be jerks. And that's part of the accepted workplace. Now, it may violate company policy, but it's not going to be unlawful sexual harassment. Sexual harassment is a type of hostile environment that is specifically set forth in the law as being unlawful. Because, again, it's based on gender. And gender is a protected class. So, hostile environment is generally defined as this: unwelcome, sexually harassing conduct so severe, persistent, or pervasive that it affects a person's ability to participate in or benefit from a program, activity, or function, or creates an intimidating, threatening, or abusive environment. There's some key words in here. Some of the key words are unwelcome and severe, persistent, or pervasive. Now, there's something you got to remember about welcome. And you mentioned, I've got it down here, per se rule. Welcome will not be a defense because minors can't consent. So in a school environment, welcomeness is off the table. But when you're in a workplace and you're dealing with adults, one of the defenses is, hey, this was not unwelcome. This was a two-way street, it was participatory, and that's a defense that someone can raise in court if they're trying to defend themselves from a hostile work environment claim. So unwelcome is one of the key words when you're dealing with adult to adult. But a minor cannot consent. So whether it's unwelcome or not is never something that comes up as a defense. If sexual misconduct happens in a school environment involving a minor, it's per se illegal because they're a minor and can't consent to sexual activity or misconduct. The other key words, particularly in the employment context when dealing with adults, is so severe, persistent, or pervasive that it affects a person's ability to do whatever it is they're trying to do. So this comes up a lot in the case law because you'll see somebody who will say something offensive and then someone will claim that that's sexual harassment, and the courts are trying to guard against a strict liability rule that basically says any inappropriate comment is harassment and you're liable for it. The courts generally are only going to find unlawful sexual harassment if it's so bad that it has actually interfered with the ability to do what that person's there to do. So that's a really important issue that always comes up in these cases, and there's always a question. And the courts, it's basically a sliding scale that the courts decide on a case-by-case basis. And there have been cases where someone says something super offensive, and because of the nature of what was said and the environment, courts have found that that single act was enough, but that's unusual. Usually a court needs to see a pattern of practice. that's severe or persistent. If it's something that's not as significant, the courts are usually going to be looking for something that's pretty repetitive. So if it's something that's a relatively minor issue in the workplace, in and of itself, it's not going to be so severe that it's going to interfere with the person's ability to enjoy the ability to carry out these activities in the workplace. But if it's ongoing, something that's relatively minor but just keeps going and going, it can arise to the level where it interferes with their ability to work and therefore is hostile work environment. Another really interesting thing that you want to be aware of is that an employer, and this means schools as well, can be liable for hostile work environments that's created by people other than their employees. So the classic case would involve, for example, the guy who delivers the water in an office environment, or the UPS guy. So if you're working in an office and the, I should say UPS person, because this could go either way, but if you're working in an office and the UPS person shows up and is harassing you, they're not employed by the employer, but if you complain to the employer and the employer fails to act or take appropriate steps to prevent that harassment, they're going to be liable, because employers have a responsibility to create a workplace free from sexual harassment. So look, let's drill down a little bit into the school environment. We're going to talk about student to teacher sexual harassment. It sounds, kind of funny. Well, you're an adult, you got a kid. Kids can create a sexually harassing environment that would probably violate school policy, and also, even though it may not be unlawful, depending on the circumstances, it can give rise to a claim against the employer if the employer, the school, doesn't deal with it. Now, there aren't a lot of cases where incidents actually arise to litigation, because schools have a lot of power over kids and a lot of ability to deal with kids. So if schools are made aware of a student who's acting inappropriately towards a teacher or a staff member, they have a lot of remedies that they can deal with, up to and including expulsion. So generally the school is going to do what it has to do. So if you boil all this down, there's really two key elements. If you forget the other stuff, you got to remember these words, and you'll know generally sexual harassment when you see it. Two elements. The behavior must be unwelcome, and the behavior must be sexual in nature. Now, because, again, we're going to be talking about the school environment, don't forget the caveat. Unwelcome is not a defense when dealing with minors. Minors cannot consent. So let's get into some more specifics now about teacher to student sexual harassment and misconduct. Some points you want to keep in mind first before we talk about some scenarios. If a student is a minor, it's probably going to be a violation of criminal law. We're not just talking about violating a workplace policy or a school policy. We're not just talking about civil liability. We're talking about criminal legal issues, because the law protects minors from abuse. And in addition, most states, including California, include reporting statutes that say certain people, they call them mandated reporters, must report abuse and misconduct if a minor is involved. So not only may it be a criminal issue, but you may have an obligation to report it, and if you don't, you could be committing a crime. We'll talk a little bit more about that in a slide or two. If a student is an adult, it may not violate criminal law, it may not be reportable, but it's still likely to result in legal liability, because you're dealing with a special relationship. Schools have a duty to their students, and this special relationship exists to provide an environment that is safe and reasonably free from misconduct. So if there's a teacher to student sexual harassment issue, even if you're dealing with an adult student, it's gonna, in every school I'm aware of, violate policy. And it's also going to create potential for legal liability, because that person can still sue the school for negligence in allowing an inappropriate relationship that could be harmful to take place between an adult and a student. Let's talk about some examples. And this is kind of a scale, not really, it's kind of mixed up a little, but you start up at the top. Teacher to student intercourse. Problem? What do you think? Probably a problem. Sexual touching. Problematic. All these things are problems. Inappropriate touching for self-gratification. Let's talk a little bit about what that is. We've had cases where, sometimes you'll have a type of touching that is clearly of a sexual nature. You may have a teacher who touches a student on the breast or on the bottom or somewhere that's obviously done with an intent to have a sexual gratification or message. There have been a couple of instances that have been kind of unique, where there was a teacher who, brushed against a student in a way that the student thought was inappropriate, but wasn't really touched in a private area. The student was pretty certain that there was a inappropriate touch going on there. The legal standard is whether the touching was being done for some kind of self-gratification of the person who was doing the touching. And you could even end up in a situation where a person is touching a student somewhere that may not be inappropriate, but because for that person who's doing the touching is doing it for some kind of sexually gratifying purpose for themselves, it becomes unlawful contact. Hugging. Okay, this one is probably in the wrong spot. Okay, this should be down here. Hugging is, in and of itself, is not a problem, but it's about the appropriateness. Where it happens, how it happens. If you have a teacher who's side hugging a young child on a playground in plain view of everyone else, that's very different from a teacher who's engaging in a full frontal, elongated hug in the privacy of a classroom. That's going to have a totally different feel and a totally different look to someone who becomes aware of that. Intimate contact, sitting on lap, hanging on, excessive contact. So we've had a number of cases where there have been some difficult calls that had to be made by administrators. Sitting on lap, I write that specifically, we had a case where there was a teacher who was in his classroom. It was after hours. No one else was in the classroom except for a female student, and another staff member happened to walk into the classroom to get something, and the teacher is sitting at his desk, and he has a female high school girl, 14 or 15, sitting on his lap, and she's got his arm around him, and they're just talking. He has one arm around, one hand on the desk. How do you think that looks? Pretty problematic, pretty poor judgment. That teacher ended up, because there had been a couple other uncomfortable issues, not as significant, but that teacher ended up losing a job over that issue. So, the amount, level, type, location of contact can be an issue. Hanging on, you'll see, and we've had situations where teachers haven't, in and of itself, you might see some contact that doesn't seem that problematic, but you will have a person who might hang on a little too long, or they drape, they'll sit and they've got the arm over or whatever. And in this day and age, as a teacher, you need to be mindful of that, because that is a problem, can be a problem. Excessive contact. We had another case, this isn't really an excessive contact issue, but we had another situation where a person who was a counselor at a school had no complaints of contact, but a lot of students were complaining that he was violating their personal space, and this was seen by a number of other teachers. For example, he's a close talker. Anybody remember Seinfeld? You ever watch the Seinfeld episode with the close talking, right? He's a close talker. In one instance, he was seen in a assembly. There were lots of students and people around, but he had this student in kind of the edge of the room, and they're sitting in chairs, and he had the student sitting in a chair in front of him, and the way he was sitting, he had his knees parted, but he was almost like had her pinned up in a corner and face, very close. And the student was very uncomfortable by that and complained about that. And one of the staff members who saw it was very uncomfortable about it and confronted the teacher about it, or the counselor about it afterwards. And the counselor basically took the position that, hey, it's a crowded environment, we're having an intimate conversation dealing with a counseling issue, and I needed to be in a position where I can talk to that person, and he had his reasons. But this other staff member who had seen this and felt uncomfortable about it was also a counselor and said, there's ways to have intimate conversations without sitting and acting in that way. Says generally, what do most normal people do? If you're trying to have an intimate conversation in a crowded environment, you'll sit next to each other, and you'll be like this, and a head here, and you'll talk, but there's no kind of boxing in, there's no sort of control. And again, this counselor, with one incident, that would probably be they would be counseled, and assuming they corrected it, probably wouldn't be an issue. But this is someone who, when they started checking out the issue, a number of students felt very uncomfortable with the way this person conducted himself, and there were a number of similar circumstances that just kind of added up in the administration's mind, and that person ended up not having a job the following year at that school. Other cases, looking down shirts. Pretty common. We've had this come up a number of times. Leering, staring, checking out students, attempting to see students in a state of undress. We had a case one time where a girl had alleged that she was sexually molested by a high school coach at one of the Adventist schools we represented, probably about 20 years prior. And what was interesting to me is I went and started interviewing the students. And the students, I'm jumping ahead a little bit, says, don't be creepy. A number of students, when I were interviewing them, would say, I never saw anything inappropriate, but he just had a creepy vibe. And I have found in almost every case I've handled that when there's an issue, if we go back and start talking to kids, kids had a creepy vibe about this person long before something even occurred in many cases. And so I tell the administrators at the schools I represent that you need to be very keyed in. If you have students complaining that there's something creepy, I'm not saying there's something wrong there, but it's something you want to pay attention to. And you need to let your students know that, hey, this is an environment where you should feel completely safe and comfortable with everyone here. And if you're getting a creepy vibe from someone, we want to know about it because we're going to deal with it. One of the things that came out in that case, which was shocking to me, was the girls who were participating, I don't remember if it was a basketball or what, but they had a locker room there where they would come and change. And this male teacher would come into their locker room in the middle of the time that they're changing to make sure that they're hurrying up and getting dressed in time for the class or in time to get back to class. And of course, that's obviously not right. And all the girls knew it wasn't right, but none of them said anything to me, which was amazing to me. I thought, well, why didn't you ever tell me? Well, Yes, ma'am.
I have a question. I don't know if this is the right place, but with all the issues about transgender and
Yes.
bathroom use, are you going to address that at some point?
I can't, in fact, so there's a significant issue that is not fully developed in the law. California now has a law in public schools that students are to be allowed to use whatever restroom that they identify, whatever restroom that they, I'm trying to remember the exact way it's phrased. So basically, whoever they identify as, they get to use that restroom, and it's discrimination to not allow it. And it is creating a lot of problems because there's a lot of people who are not real keen on that. And how do you deal with the dressing issues and things like that? It's a very unsettled area of the law, and it's particularly challenging in the private school environment. Because in the public school environment, you don't have as many religious moral issues that you have to deal with. The private schools have not been mandated to do that yet, but there is a push towards that direction. And for one example, CIF, which is the Student Interscholastic, California Interscholastic Federation or something, they have rules that they have to comply with the state rules, but we have Adventist schools that are in CIF. So there's going to be some issues with Adventist athletics if they ever come upon a situation where they have to make that decision and they choose not to allow a transgender student to use the locker rooms and restrooms with the gender they identify with. It will raise some issues about whether those schools can continue to be eligible for CIF. So that's it'll be a very interesting area of the law over the next few years.
But right now, it's so up in the air.
Right now, it's very up in the air. And not to digress too far, but it's complicated by the fact that, when you look at, for example, sexual orientation issues, obviously our private schools deal a lot with sexual orientation issues. The church has a position on that. So whether people agree with it or not, you kind of know where the rules are. Transgender, the church has no official position on transgender, so it's very difficult even for the schools to know what should we do, what shouldn't, what are the parameters, and this church is kind of struggling with that right now to figure out how are we going to address this issue and give our schools guidance.
Thank you.
Inappropriate comments about appearance, physical attributes, attractiveness, attraction, prospective relationship, or other similar comments. We had a number of cases where you'll have teachers who will, and I think in some of these cases very innocently, trying to build up the esteem of a student of the opposite sex, will make comments about, you're beautiful, don't let it get to you, or you have a very attractive body, or that it can get, of course, very inappropriate when they start talking about particular physical attributes. They may talk about, I have an attraction to you. Okay, you're obviously crossing some lines. Cases where they've said, hey, if I were in high school, I would totally date you, stuff like that. And of course, the excuses that you get is, well, I'm just trying to build their esteem. You know what? I'm not in their head. Maybe they are. But you should be using your head that that's not appropriate. And you're going to have issues with sexual harassment / misconduct right there. The don't be creepy rule. Not as big of an issue for the lady teachers, but there is definitely a creep factor that some people can put off, and the administration needs to be really tuned into that. And hopefully the students will feel comfortable enough they can express to administration if they feel that there's some creepiness going on, and the administrators should take it seriously, because in my experience at least, the cases that I've handled, unfortunately in many cases where there's smoke, there's fire. Let's go through some mandated reporter stuff real quick. So if you observe some student involved sexual misconduct involving an adult, the rule of thumb is it's going to be reportable. California and most states have a rule that says if you're a mandated reporter, which always includes teachers, when you form in your professional capacity or within the scope of your employment knowledge from observation, or if you know or reasonably suspect that there's been some abuse or neglect, you got to report it. And the way it's reported is, let me get ahead there. The way it's reported is you have to report it to law enforcement or a child protective service immediately by telephone. So the first thing you got to do is pick up the phone. Then it has to be followed up within 36 hours on a special form in California, a written form that's going to ask for a bunch of information. My rule of thumb is when in doubt, report. Or if it's a real wobbler, there's no harm in calling and asking, hey, I got a situation. I don't know if it's reportable or not. What should I do? And then they'll tell you, whether they think it's reportable or not. You fulfilled your duty then. And they may say it's not reportable, deal with it internally. They may say it's reportable, we need you to file the report. Do what they say, document your conversation. Now, one of the things that will come up is that you may tell your principal what the issue is, and your principal may say, I will take care of it. And then you say, okay, great, I don't have to worry about it anymore. California and most states make it an individual responsibility. So every person who has that knowledge or reasonable suspicion is a mandated reporter, and you have to make sure it gets reported, because you will still be liable. For example, if the principal tells you he'll do it, but then he doesn't, you're still potentially criminally liable for the failure to report. You need to make sure that they actually make that report, or that they allow you to make it. And many times they'll have you make it and just be present. Briefly, before we move on to the next one, reasonable suspicion. Okay, this is kind of an important concept that's hard to define, but the law says reasonable suspicion means that it is objectively reasonable for a person to entertain a suspicion based upon facts that could cause a reasonable person in a like position, drawing when appropriate on his or her training and experience to suspect child abuse. Basically what this is saying is a jury is going to weigh your decision, and they're going to say, was it reasonable? Based on who you are, what knowledge you have, and what the situation was, and what you saw, should you have realized there was a problem? If you get to the threshold where you have that reasonable suspicion, I think something's going on here, it's reportable at that point. You do not have an investigation obligation. You're not an investigator, and you should not try and investigate everything to figure out for sure what happened and how. You only need to get to the level of reasonable suspicion. So I have cases where an administrator will say, I've got this, this, and this. I don't know if there's an issue here. And so our advice is, your job is, if you haven't reached a reasonable suspicion yet, but you think there's something going on, your job is to ask just enough questions to decide if there's something here or not. And once you get to that reasonable suspicion, report it. Don't go interviewing all the kids and everybody involved in the alleged perpetrator, because you're just going to muddy up the investigation. You got to leave that to the professionals. That's what the police are for. Student to teacher sexual harassment and misconduct. Okay. This is a unique environment because you have all the power, typically. So in many cases, when you're dealing with a kid, because of that imbalance in power, you may be able to resolve the issue right then and there. Some boy makes some inappropriate comment to you, or vice versa. Girl to a boy teacher, whatever. They could say, hey, that's really not appropriate. The school has policies against it. You need to stop it. And they may stop, and that may be fine, because they know that ultimately they're going to get in big trouble if they don't do what the teacher says. In the event that doesn't solve the issue, and there's a continuing issue with harassment, then you can almost be certainly assured it's going to violate school policy, and that the administration is going to want to know about it, because they have a responsibility to deal with it. So typically, that gets reported to administration. They have a responsibility to protect you, their employee, from sexual harassment. And student conduct that isn't controllable by the teacher should be reported, and the administration should take care of that for you. Dealing with the student crush. This is a major danger area, and it's particularly in the earlier years. I mean, for obvious reasons, teacher comes in, they're gonna be a lot closer in age in their early years of teaching. They may not be married or even have a significant other of any kind at that time. And it's very likely that a student of the opposite sex or same sex, who knows, may be attracted to you, and you're gonna have to deal with that. And so you need to be, the first thing is just being aware of it as an issue, and making sure that as much as it may flatter you, and the flirting may, be tempting to engage in, you gotta know that this is totally off limits. There's a teacher-student relationship here, and you've gotta be smart and protect yourself. I have seen, unfortunately, a number of careers ruined on claims that sometimes may not be true. Sometimes they are true, but could have been easily prevented if the teacher had exercised some discretion. So you have a lot of control over the ability for a wrong claim to be made against you, and you have a lot of control over the ability for things to get to the point where it becomes a problem. Avoid appearances of wrongdoing. Be mindful of student attraction. Whenever possible, have someone else present for private or sensitive conversations with students of the opposite sex. Windows is a big one. Most of the Adventist schools now have retrofitted all of their classrooms and teacher offices and things like that to have windows in their doors. If you get to a school and there is not a window in a private office, you need to demand, as politely as you can until they do it, that they put a window in. Windows do, it's amazing, you would think really, but they make a big difference, because what happens is, if you have somebody make a claim against you, it's not very credible to a jury when the lawyer, me, gets to sit there and say, well, there's a window in that door, right? Yes. And that goes out to a hallway? Yes. And people can walk by there at any time? Yes. And they can see in if they look in? Yes. Juries are not going to find it credible that a teacher took off his clothes and raped you in a room where there's a window that someone could walk by and see. So windows are very helpful. I just wrapped up a case very recently with a pastor who had a parishioner who was unfortunately very mentally ill, and she was convinced to the point that she received a mailer for a church. I forget what it was now. It was like literally a church picnic. When she received the mailer, she was convinced that it was evidence from God that the pastor wanted to marry her and that she needed to be there so that she could flirt with him and put the moves on. And that was her deposition testimony. She made some outlandish claims, but he knew he was dealing with an issue, so he was very careful. He had windows in his office, they were always open, and he made sure he had elders at the church whenever he had to meet with her for any issue. So eventually she actually did accuse him of some sexual misconduct. But because every time she was there, he had windows, they were open, and he'd gone the extra step of having other people in the environment, not in the office, but outside, it destroyed her ability to assert that claim. Exercise restraint with physical contact. We already talked about that a little bit, but be mindful. This is a reasonableness scale here. I'm not going to be that guy, because there are those lawyers who will come in and say, don't ever touch a kid. That's crazy. There are risks. You just need to recognize there are risks. Exercise judgment. Kids need love. They need physical and emotional support in every way they can get it, but do it in a wise way. Exercise your judgment. Lastly, we need to talk about student-to-student sexual harassment and misconduct. Most schools are going to have bullying policies, or they're going to have sexual harassment policies that say student-to-student sexual misconduct is not allowed and subject to discipline. It also might constitute a crime. I'm not going to get into the weeds too much on this issue, but you just need to recognize that some conduct between minors can also constitute a reportable crime. Usually the laws are kind of complicated, depends on the age separations. So certain students, if they're not that distant in age and they engage in what appears to be voluntary sexual activity, it's not reportable under the mandated reporting statutes. You may have a student who's a 3-year or more age gap, or there may be some indications that there's some coercion or duress in the relationship. That is going to arise to the level of a reportable child abuse. So whenever you have a situation like that, let the principal know, hey, this is what I'm dealing with, and the principal will hopefully work with the legal counsel to figure out, is this something we need to report, or is it just an internal discipline matter? Child pornography. Okay, kids are sexting each other with their cell phones, minors. I'm very torn on the approach that has been taken by certain district attorneys on this issue, because legally, the way the law is defined right now, if you are a 17-year-old girl and you take a picture of your nude body and text it to your 17-year-old boyfriend, you are guilty of felony child pornography. And there have been some district attorneys who have felt that it was important to make examples and have charged teenagers with child pornography, which, you know, as you can imagine, now you're a registrant and marred for life with felony child pornography. It's a real, I do not agree with that prosecutorial approach. Most prosecutors do not do that, but the issue is reportability. Okay? You will be mandated to report electronic transmission of sexual natured images between students, because in most cases it's going to constitute child pornography by the very fact that these are children sending pictures of themselves. Sexual misconduct between kids can often be a form of bullying. Bullying has gotten a lot of attention over the last few years, and schools are getting a lot better at creating anti-bullying policies, and a lot of times the bullying will include a sexual component, so of course violates policy and can be a real problem. All of this is complicated by the social media aspect, cell phone aspect, internet. Kids can get on the internet and do all kinds of things. They can do all kinds of things with their phones, and they can sexually harass each other without even being in the same state. Now, I've been advocating, and most of the Adventist schools that I represent have adopted policies, because we're Christian schools. We expect a certain standard of conduct from kids who attend our schools. And they don't have the same kind of rights that they would at a public school to free expression and free speech and private property rights when they're not on school grounds. Our kids can be held to a conduct standard. So most Adventist schools now have adopted policies that will say, when you come here, you recognize that this is a Seventh-day Adventist school. There are certain expectations of Christian conduct, and if you violate those expectations, whether it's on or off campus, you could be subject to discipline. So if you end up with a kid on a Saturday night in his own bedroom, on his own computer, and he's doing some social media sexual harassment of another student that is affecting, that's becoming known to other students or affecting the school environment, that school has the ability to address that as a disciplinary issue. So you'll want to know what your policies say. How far do they go? Some public schools do not go that far for various reasons. So you'll want to know, what is your policy? How far does it go? Because you may need to address even off-campus, private time conduct on private devices. Don't ignore it. You got to make sure it gets addressed, because failure to deal with it creates a liability situation. Schools will get sued if you have a student who's being harassed, whether it be physically or sexually by another student, and the school knows it but doesn't do anything about it. That's a liability issue. The schools are negligent in that case. They have a legal responsibility to create a safe environment to the extent they can. And schools have been held liable for failing to act in cases where they're aware of it and do nothing. So that's it for the presentation portion. I don't know if anybody has any questions about anything we covered. I'm happy to address anything you like. Yes, ma'am.
I would like to comment to the students that are going to be student teaching. The first thing you should ask when you start at your placement is to see the school's policy on sexual harassment, reporting, everything, because every school could be different or every county different. So that's one of the things you need to think about when you first start, is to find out what the school's policy is.
That's right.
Very important.
You'll want to get a copy of that policy. You're going to want to get a copy of their own sexual harassment and policy for employees, employee to employee. You also want to find out if they have, sometimes it'll all be in one policy, sometimes they're going to have separate policies, but you want to see what are their electronic use policy. For example, schools have computers and devices a lot of times. They'll have a policy that governs what can kids do with that, what can't they do with it, what websites are they, can they not visit. Does that policy govern their personal devices, or is it some other conduct policy that governs what they do on their own devices? You want to ask what those policies are, and then usually they'll have a privacy policy that also governs what the student's expectations of privacy are on search, because you may come upon a situation where you hear from a student that another student is texting sexually inappropriate images to a student, or that a student is sexually harassing a student via text or something like that. Depending on what your school's policies say, especially in the private school environment, you are usually able to take that phone, and look at the text messages or look at the pictures to find out if what you heard is actually true. Public schools have a much different standard. It's tougher in a public school. So whether you're in a public or private, you want to know what are your search and seizure policies so you know what you can do. Because sometimes, you'll be in the heat of the moment. You hear about something, that now you got a phone in your hand. What can you do with it? So you want to know what your school's policies say so you know you don't create liability to the school by violating a policy if, for example, a public school says you can't do that. Any other questions? Yes, ma'am.
Okay, so I have two questions. The first one is what is our role with CPS? I have a friend who is the principal of a small school, and she recently had CPS show up unannounced and want to talk to one of the kids.
Mm-hmm.
And she was like,
Yes.
what do I do? So she called her superintendent, who said, hold on, and called the guy at the conference, and then all three of them were on the phone together, and she was like, is this the first time we've ever dealt with this, or what? I mean, it seems like somebody should have an answer for me right away. In the meantime, they just said, try to stick with the kid as long as possible, and I think she did, but so then there was this other hiccup that happened. He's talking to the kid, called him by his first name only, whilst the principal is sitting next to the child still.
Yeah.
Comes to find out it was the wrong Johnny. So Johnny is traumatized and goes and gets the right kid because that Johnny was at another school.
Oh my word.
And so what is it as
Yeah, that's a great question.
I will be the sole teacher of a 1 through 8 school as well. And so I want to know what my job is. If I have CPS show up, do I just take their word for it when they can, one, mess up like that, and two, totally traumatize the kid?
Yes.
I mean, that's...
I know. Let me give you kind of a general overview, and then I'm going to tell you what my recommendations are.
Okay.
I have dealt with this a number of times for schools in different conferences, and it actually differs depending on the state, because some states have parental rights laws, some have none, some have some parental rights laws that are more robust than others. There are states that will say if the student, that they have to notify the student can ask for a parent, or that they can't speak alone with the student without consent. That's pretty unusual. In most states, the rule of thumb should be in your mind that they are going to have a right to speak with that child, because most states consider it a public safety exception to privacy rules, and they'll say it's for the safety of a minor. CPS can come in and talk to that child without notification of the parents and without parental permission, and they can speak with them alone. So what I generally tell the administrators that I deal with is that this is the way you should approach it. CPS shows up, they want to talk to a child. You say, okay, can I be present? Or you should say, I will be present.
Mm-hmm.
Let them tell you, no, you can't be. If they tell you, no, you can't be, respect what they tell you, because if you push the line, they may hit you with an obstruction of justice charge, which would be a problem. So you should say, I'll be present, let's get them, let's do it. They may tell you no. In that case, the next question is, I need to know, the parents are going to find out, they need to know, can I notify them now? They may say, you can notify them now because we'll be done by the time they get here, or they may say, you cannot call the parents until we're done, or they say, do not tell the parents anything. It's an ongoing investigation and you cannot report to the parents. Whatever they instruct you to do, you want to document and then do what they instruct. Because that way, the parents will come, they will be upset. Why didn't you call me? And say, look, I'm sorry, I asked if I could call you. I was instructed that I could not call you, and therefore I did not. And what are the parents going to do? That's the best you can do.
Okay.
So that's kind of my general instruction on that issue. There are some states where CPS has to provide the student a right to ask for an administrator or some other trusted person or an attorney or something.
Is that California?
It's Arizona. California does not. So it depends on the state.
Okay.
So you may want to, as part of your getting up to speed in whatever state you end up in, it's usually not hard to find out. There's websites actually that kind of summarize a lot of this information. They're usually parental rights websites, but they'll have the law and basic information.
Okay. All right, so my second question
Yes.
is, being the sole teacher of a one-room schoolhouse for the most part, and I might sound paranoid, but I am a parent, and so I'm concerned about sending kids out to go to the bathroom more
Yes.
than one kid at a time.
Yep.
I'm the only person there, and even if there was more people on staff, they're not gonna be like standing in the bathroom.
That's right.
But it'll be a one-room schoolhouse with grades 1 through 8. I personally am not comfortable with anybody, more than one kid going out at a time,
Right.
and yet is that practical?
Right. So we actually defended a lawsuit, we resolved it about a year and a half ago, where a kindergarten student, two kindergarten students got engaged in some inappropriate sexual conduct with each other in a school restroom. And the school was sued for negligent supervision, because the argument was the teacher should not have allowed them to be in there together, or the teacher should have supervised the situation better. We got the case resolved because kindergartners, what happens is when you get sued, I, as a defense lawyer, will find experts who will hopefully tell us what the standard of care is, and that's based on practice. And then hopefully that standard of care happens to be what our people did. Sometimes it isn't, and we end up paying all those cases. In that case, I said kindergartners are expected to be able to conduct themselves in an appropriate manner for a short period of time. The teacher was right outside the restroom, they found that reasonable. So in your case, what you have to look at is you have to look at, using your experience and judgment, the age of the children. You have to think about, do they have any kind of discipline or behavior history, because you're gonna have to be more careful and diligent with those who do, and make the best decision that seems reasonable to you. And the way I put it to people is, you think about it this way. Every class is different, every kid is different. Legally, you can send kids alone to a restroom. You can send a couple kids alone to a restroom, but it has to be done reasonably. You don't wanna send kids that you know are problems. You don't wanna send them to a distant restroom where they're in danger and you never check up on them. There's a whole scale. So you just need to be thinking, under your circumstances, what can I sit in front of a jury or a judge and say, with my head held high, I love my students, I care about my students, and I am always very careful about how I just choose who goes and how, and here's how I made that decision. You know, these students were good students, they had, they were older, it was appropriate. Whereas a younger student, maybe you would have said, no, I'm not sending that student.
Right.
And that's a purely judgment call that you need to do. There's not a legal rule, unless you're dealing with preschool.
Right.
Preschool students, they have to be supervised at all times. But above that level, it's a judgment call and it's a sliding scale. You know, it gets more onerous the younger the kids. When you get up to high school kids, you're in a whole different ballpark then.
Right.
I know it's not an exact
It's not,
answer,
no.
but it's, it kind of gives you the parameters of the issues that you gotta be aware of.
As a teacher, you are concerned about your own career, but even more so the kids, and you just
Absolutely.
don't want any of that to happen.
That's right.
You just don't wanna go down that road.
That's
And,
exactly right.
and yet you don't wanna be a micromanaging, fearful teacher that
That's right.
pushes off that vibe onto the kids. So, it's
Yep.
just this balancing act.
It is a tough balancing act, and it's only one that can be made by the teacher in the environment, knowing who these kids are, what their behavior is like, responsibility levels, and it's gonna be different for every kid.
Okay.
Any other questions?
Hey, I had a question.
Yes.
So, we understand that once we get our full-time jobs, all of these things that we've talked about apply. Is there any difference in responsibility at the student-teacher level? In, for instance, like the mandated reporting. If I were a student teacher and I think the kids in my class, there's,
Something going on.
something going on, I tell my cooperating teacher about this. Do I trust that my cooperating teacher will take the appropriate action, or am I also in that line of responsibility now to see that something happens? Are there any gradations in responsibility with any of these
So
things that
there
we've
are,
talked about?
interestingly, in California, to go kind of further down the scale,
Mhm.
a volunteer is not a mandated reporter. You could have a volunteer in California working in a school, they are not a mandated reporter, whereas in Arizona or other states, they are. Question?
So, okay,
Disagreement?
I'm curious, at our church, we have to shield the vulnerable.
Yes.
And that thing tells us we're mandatory,
So here's the thing, it depends on the circumstances, but
Okay.
volunteers in California, under many circumstances, are not defined as mandated reporters.
okay,
Now, the law could have just changed, but I can tell you that we're taking a very conservative approach, and we tell our volunteers
Okay.
they're mandated reporters,
okay,
because they're mandated under our policy.
yes, okay.
But
makes sense.
but in California, they would not be legally liable.
Okay,
And I'll double check that, so you can edit that out and fix it. We'll read
Right,
out
well-
with the correct, but as of the state of the law, a year and a half ago, the last time I had to research it, volunteers were not yet covered, but most states are filling that gap.
okay.
Most states are now saying, if you work with kids, I don't care who you are, paid, volunteer, whatever, you're a mandated reporter.
Okay.
For most of the time that I'm aware of, including up to now, in California, it's employees. Volunteers are not, but of course they're heavily encouraged. Now, all that means is you may violate school policy by not reporting. You might get sued and be civilly liable for not reporting, but California has not made it a crime for not reporting.
Okay.
They've made it a crime for teachers to not report.
Okay.
So bumping up the scale a little bit, California has a definition of a mandated reporter. And so to answer the question for a student teacher, you'd have to look at the definition. Now, does a student teacher get paid?
No.
Okay, if a student teacher doesn't get paid, now the next question is, are they considered an agent? And are they a volunteer? Are they an agent? I would argue on the side, without having researched it, I have to research it, but I would argue on the side that you are a mandated reporter, which means you have the exact same responsibilities, but they will be applied to you differently. Okay? I think California would say you have to report, but when the jury is weighing your case versus your case, you're very experienced, you're an instructor. If anybody knows how to identify child abuse and where a problem is and that you need to report it, you would. A student teacher, remember the reasonable suspicion. It talks about like situation with like experience and training. So if you're a brand new teacher, you don't have a lot of experience and training in it, you will be held to a lower standard for your failure. If you miss something, the jury can consider that in deciding whether you should have known something or not. Any other questions? All right. Always a pleasure. Appreciate it.